the epic trade dress battle over the Nespresso pods that you see right here. Hi, my name is Derek Fahey. I'm a registered patent attorney and a trademark attorney with the Plus IP firm. And this is going to be a video about the trade dress that you see here that's owned by Nestle, the Nespresso, the company that sells Nespresso pods, and what has happened in this litigation for the last couple of years. So essentially, let's back up. Nespresso, they sell pods. They actually got a registration for the shape of the pod, and they describe the shape of the pod. It's a conical shape. Okay, it's kind of a conical shape, and it's got this dimple at the center of the cone. And essentially, Nespresso filed for the registration of the look and feel of the shape of this pod. And they filed their application to register that because if you get to register the shape and the look and feel of the product, you can prevent other people from selling products that look and feel like it, essentially in perpetuity, as long as you have trademark rights. Trade dress, like a trademark, allows people to identify a particular good or product with the source of the good. In this particular case, when you see this product, what do you think of? You think of Nespresso, you think of somebody else? Well, Nespresso argues that you see the shape of this product and you think of Nespresso. I mean, I certainly do. I own an Nespresso machine, full disclosure, love this stuff. But essentially Nespresso filed to register, and then they began to enforce these brands because this trade dress against other alleged infringers that were infringing or selling products or pods that could be used within an espresso machine. So it's a really brilliant way of preventing other people in perpetuity, essentially, because trademark rights last as long as you lose it, as long as you use it, to prevent other people from using and selling products that look like this. Now, trade dress, typically, in order to protect the look and feel of a product, you actually have to show, you can't just file it and register it. You actually have to show that the product is established what's called secondary meaning. The look and feel of products are actually not considered inherently distinctive. You actually have to show large amount, or that consumers identify the look and feel of the product or the shape of the product with the company. So Nespresso, what they did, we filed an application. The office, the United States Patent and Trademark Office, actually issued a rejection stating that the look and feel of shape was not inherently distinctive. In response to that rejection, Nespresso responded with all these marketing and advertising information explaining why the look and feel of the product was well known, and establishing that they actually own the rights to it because people identify the look and feel of the product with Nespresso and the owner of the rights itself. In addition to that, the Nespresso also had to respond to the fact that this particular product could be functional. So in the rejection, the patent office, one of the things that they can argue is the look and feel of the product is functional and you're not entitled to get a trade dress. So in order to get trade dress, not only on a particular product design, you have to show that these features are not functional. The trade dress is not functional. And what the patent office argued is, well, hey, you actually have utility patents. Here's actually one of the Nespresso utility patents that show this conical shape and have, where you actually, where the puncture, where this part goes into it. And they said you actually applied for utility patents on these particular products, and it's therefore functional. And because it's functional, you actually can't get the rights to the actual trade dress right here, okay? Ultimately, Nespresso won. They argued several arguments. They actually argued that the advertising material don't actually tout the functional features of the product. They said these advertising materials, we're not saying that this dimple is functional, we're just saying how amazing the pods are, and thus we're not, this feature that you see here, this dimple feature, is not functional. They also argue that the dimple feature was not essential to the use of the product. They actually showed used pods where the dimple was actually not inside of the hole. So they're saying, listen, even though we have this feature, we don't really need it for the actual functionality of the product. So they had some arguments to argue that it was not functional in order to register it. Now, after it was registered, you had a whole lot of competitors that actually filed what's called the cancellation proceeding. And the cancellation proceeding essentially said, hey, listen, trademark office, you made a mistake. This should never have been registered. We're going to cancel the registration because it is functional. And, you know, they have all these utility patents. And because they have these utility patents, it's actually functional. They had experts' opinion as to why this is functional. And you should cancel this registration. Now, Nespresso has this registration, so they actually have proved that they have met the initial burden. They actually their devices are not functional. So they have this registration. They actually go to federal court in New York and file a lawsuit against Williams and Simona. Williams and Simona, and argue that the brands, their mark is actually registrable, and people recognize the good and the goods with them, and it's not functional. They sue. Nespresso sues all the defendants, and for about 2.5 years, they litigated over this exact issue about whether or not these particular capsules were functional. Ultimately, the court never decided the issue, and the parties settled. Essentially, this registration is still active. That means that how arguably Nestle, which is the owner of Nespresso, they actually have the rights to this look and feel of the shape with this dimple, and they can prevent other people from importing goods that look like this into the United States, and also prevent people from actually selling the goods in the United States. Now, why is that cool? That's because you can actually record this registration with the U.S. Customs Office, and you can actually tell customs where you think the products being imported in, and they can potentially seize the products that are coming in that are infringed on, that look like this, that's not a product of Nespresso. So I thought that was really interesting. We really, at this point, will not know for sure whether or not this particular dimple structure was functional. There's arguments on both sides, but I just think it's really interesting to consider how they actually went about registering this shape, because they actually now have the rights to this shape, assuming nobody challenges it, in perpetuity, because trademarks and trade dress last until you stop using the product. So I thought that was very interesting. Please like and subscribe to my video if you like this topic. I post stuff on trademark and IP law quite often. My name is Derek Fahey. I'm a registered patent attorney with a Plus IP firm. And you can actually find me on Instagram, Derek Fahey PA, www.plusfirm.com. Hopefully you enjoyed the video and come back and see us soon. Thanks.